Assalamualaikum warahmatullahi wabarakatuh, and a very good day. So we have discussed in our previous discussion in regards to the common law grounds for discretionary actions or discretionary powers. So we have discussed substantive ultra vires, the grounds for substantive ultra vires. So today, for this video, I'm gonna highlight in terms of procedural ultra vires. So when it comes to grounds for taking action under procedural ultra vires, we divide the compliance issue to two separate procedures, either non-compliance with express procedures. When it comes to grounds for procedural ultra vires for discretionary powers, we divide the situation or the circumstances into two. The first one is non-compliance with express procedure, and the other one is non-compliance with implied procedures. So let's have a look first at express procedures. So basically, non-compliance with express procedures refers to not following mandatory procedures which has been expressly established by law. So if the decision or action taken by the authority fails to observe the procedural norms which are mandatory and prescribed by the statute, clearly mentioned in the statute, then the decision or action can be challenged. So when a public authority fails to preserve procedural rules that are expressly laid down in the statute, then there is procedural ultra vires, meaning here there is non-compliance with express procedures. These are considered procedural impropriety, and it is a ground for judicial review. Right? There's a case to explain the matter. This one is Vires against Menteri Hal Ehwal Dalam Negeri. So this case differentiate between mandatory procedure and directory procedures. For the particular case, Vires here wasn't issued copies of Form 1 under Rule 3.2, Paragraph 2 of the Public Order and Prevention of Crime Procedures. So it's just a matter of documentation actually in this case. So in this Vires case, the detainee was only provided with one copy of the form. So the court pointed out that without this copy, he might well be at a disadvantage in proceedings before the advisory board. So the court decided that there is issue with the decision made and there is non-compliance with a mandatory rule which cannot be condoned even if no prejudice had ensued in the case. Okay, there are a couple more cases which you can look or read through by yourself. Okay, there are other cases. For instance, UUM against Mutiara binti Muhammad. In this case, the respondent, Ms. Mutiara here, claimed that there was procedural impropriety in the process of dismissing her because the university should have applied the Universities and University Colleges Act 1971 or AUKU instead of the Statutory Bodies Discipline and Surcharge Act 2000, since UUM was not a statutory body back then. So the court held that UUM is a corporate body which falls within the meaning of a statutory body. Hence, all disciplinary matters can be governed by Act 2000. So these are some of the cases whereby the case was brought on grounds of procedural issues. Okay. All right. Next, we move to non-compliance with implied procedures. So besides express procedures, which is mentioned clearly in the statute, most common law cases or countries in common law countries which follows the common law, like Malaysia, are also willing to imply some procedural safeguards against improper or wrong use of powers and to act within procedural fairness. So one of the most important implied procedural safeguards are none other than the rules of natural justice. Okay, so what is it about rules of natural justice that makes it a very important principles of fairness procedural fairness. So RNJ, the short form, we call RNJ, is a procedural safeguard against improper exercise of power by public body. So it protects the rights of individuals, enhance public confidence in the process. Okay, so the rule of natural justice is the minimum standard required by law for administrators to fulfill before making their decisions. It is a very essential principle because nowadays administrators plays an important role, a major role, and enjoys vast powers to interfere with the rights of person and property of individuals. So let's have a look at what are the principles entailed under the rules of natural justice. Basically, the rules of natural justice, or RNJ, consist of two basic elements. The first one is audi alteram partem, and the other one is nemo judex in causa sua. So if you can see here, audi alteram partem refers to the right of hearing or right to be heard, and nemo judex in causa sua actually refers to rules against bias. So this is the first element, and this is the second element. So our discussion of rules of natural justice will follow this diagram here. So as I said just now, the first element is right to be heard, and the second one is rules against bias. When we come to the discussion of right to be heard, there are two important factors that need to be considered. The first one is notice, and the other one is hearing. Whereas for rules against bias, there are three categories of bias that which we should observe in case it appears or it is present in any of the case or any of the procedures involved when dealing with decisions by administrators. So let's first go into audi alteram partem, or right of hearing or right to be heard. So as I said just now, there are two important elements under right to be heard, that is notice and hearing. So when we come to notice, we are talking about cases whereby persons are alleged or accused, so they should have a reasonable opportunity to defend themselves properly. Okay, so before they can defend themselves properly, they should be able to be given information in regards to what are the charge involved, and also given them time to actually look into the charge. So first, they should know what is the charge. And the second one, they should be given enough time to answer to the charge. Okay, so you can read the details of how important charge and allegations are. All right, among others, you should know that the accused must know his or her charge allegation. It has to be clear. It has to have all the information and details in regards to the accusation. Okay. All right, in regards of time, we are talking about elements of notice here also in regards to the allegation given, plus the notice given to the parties involved in order for them to have the time to prepare their defense. So the administrators must not only serve the notice to the accused, but they must also give them sufficient time to prepare their case. So it is against the RNJ to call upon the alleged person to show cause immediately without giving him or her time to consider the charges against him or her. So how long the time should be given depends on each individual case and the seriousness of the case. Okay. We have a very famous case, Pang Mohsin here against Commissioner of Police. In this case, Mr. Pang here was accused of corruption and he was called for a hearing. But he was told of the charge against him just before the hearing commenced. So it's a very limited amount of time given to Pang Mohsin. So when the plaintiff requests that his hearing be postponed so that he could prepare for his defense, it was refused. And later he was dismissed after the trial, and he brought the case to court to challenge his dismissal. The court held that dismissal was void on the ground of insufficient notice given to him of the charge made against him. All right. So the next element is hearing. So just to recap back what we discussed just now. So the rules of the first rule of principle of rules of natural justice is right to be heard. So the important element when we come to discussing right to be heard is the element of notice and hearing. So under notice, there should be enough notice given to the accused person, and also time. So there must be enough time. Next, we come to the factors or the element of hearing. All right. Once the requirement of notice is fulfilled by the public authority, it is essential to determine whether a hearing has been conducted. So there is no specific or fixed hearing procedures that must be followed. But so that it could be in any forms. It could be in oral, in the forms of oral hearing. It could be written submission. It could be through representation, consultation, interview, dialogue, and other matters, other modes. I mean, so the guideline usually, for guideline purposes, usually oral hearing is usually conducted. Okay, especially if it is a serious case, it is complex and involve technical questions of fact, and especially if a person's reputation is at stake. When it comes to hearing, there are a few things that the public authority must make sure so that the hearing is fair. Among others, disclosure of all information, evidence, or material used against the individual must be allowed. So there must not be any element of surprise in the hearing. Okay, so you can read through the cases in the boxes. The second consideration is that the authority should accept all the evidence and relevant material which the party may wish to produce for in its defense. This may include statements made by witnesses of the accused. The third consideration is the authority should give the party concerned an opportunity to rebut the material against him. So this can be done by giving the accused a chance to cross-examine the administrator's witness, or even to be represented by a lawyer or counsel. Apart from that, there are also some people who consider that authority may be obliged to give reason for the decisions made, so that it is possible to determine whether the authority has acted within the provisions of the law or not. All right. The second main elements of rules of natural justice is nemo judex in causa sua, or the rule against bias. So in any judicial decision making, the judge must be impartial and neutral, in a position to apply his mind objectively to the controversy he has to decide. So there are two important maxims that underline the principle of rule against bias. The first one, a man should not be a judge in his own case. In other words, whoever adjudicate a hearing or a case, administrative matters, must not be a party to the dispute in which he also has an interest therein. The second maxim is that justice must not only be done, but must be seen to be done. So it's not just necessary to prove that decision was in fact influenced by bias. It is sufficient if there is a reasonable suspicion. Meaning here, kalau ada suspicion, ada bias pun sudah memadai untuk menunjukkan bahawasanya berlakunya bias. So there are three types of bias. It could be considered under the principle we call pecuniary, personal, and policy. Pecuniary bias refers to whereby the person chairing the hearing or the person adjudicating the case has monetary interest in the case being decided. Okay. Contoh macam case Dimes against Green Junction Canal ni. So a public limited company filed a case against a landowner. So the Lord Chancellor, who was a shareholder in the company, okay, this company, heard the case and gave the desired relief to the company. So the House of Lords quashed the decision because the Lord Chancellor's pecuniary interest in that company. Lord Chancellor ni dia macam Datuk Bandar lah macam tu . So dia ada saham dalam syarikat yang bawa kes terhadap seorang tuan tanah ni. So dia bagi menang. So bila dibawa untuk judicial review, kerana dikatakan ada elemen bias, so the House of Lords ataupun mahkamah paling tinggi di UK pada ketika itu setujulah there is pecuniary bias. Okay, personal bias usually happens when the adjudicator has a relationship with the person being tried, either as a relative, a friend, business partner. So the relationship can be a positive one or a negative one. So it can be your friends, your family, or negative maksudnya your enemies, your rivals, your foe. Okay. So the test is to see whether there is likelihood of bias, and this is ascertained with reference to the right-minded person. All right, I think that one's fairly very easy. Okay, policy bias. This one refers to when a person sits in a panel where the policy that he formulates is an issue. Meaning here, katalah satu ketua pengarah jabatan buat satu polisi, and then ada orang tak puas hati, so they bring a case to court and argue about the case. They tak setuju dengan polisi tu, then dia file a claim or a complaint. So for the complaints hearing, is the person, the ketua pengarah yang buat polisi tu yang dengar. So of course lah dia akan argue kata polisi tu okey dan sebagainya. So itu pun ada satu bentuk bias kat situ ya. Alright, so that is about procedural ultra bias.